the meeting to order, and then I'm going to ask Brittany to explain a few of the ground rules. This is the first time doing this for all of us, and so as we're flexible, I think that'll be awesome. We are supposed to be done at a hard stop at 4:30, so we'll work toward that end. And I do want to offer something. This, just given the COVID thing, we're now going to accept sponsors. And so this program is brought to you by Connor O'Meara, who is a friend of ours and does a radio show, and we'll hear from him next week. He's the son of Seamus O'Meara and a very special man. And so we're just going to raise money however we can for the COVID virus. So if anybody else wants to chip in next week and start to sponsor these meetings, that would be awesome. Actually, he didn't pay anything. This is a public service announcement. So Brittany, with that, do you want to offer us the ground rules about how we're going to conduct our work here, and then we'll move on to our business. Thank you.
Certainly. So members, similar to our in-person hearings, conversation will flow through the chair. If you would like to be called upon, you can use the raise hand feature on Zoom. Tom Brennan and I will be monitoring that and letting Senator Abeler know. Otherwise, I think everyone should have my cell phone number, and you can certainly text me as well. I'm not sure if I'm missing anything, but Senator Abeler, Mr. Chair, certainly you can call on me if I need to explain anything more.
Well, I do appreciate that, so we'll see how this goes. We have a relatively robust agenda. We have two bills to do, and they both require amendments, and there's a number of amendments. With all that being said, I want to make sure each person has an opportunity to speak as they like. The plan is to move Senate File 3222 out today, and the intention of that is to move the bill with the expectation to pre-conferee it with the House, and then when it gets to the floor, there'll be other technical amendments, and some of the chapter articles 4 and 5 will be worked out by then. Either they'll survive or they won't. And most of the rest of the bill, I think, will hopefully be acceptable to the House. We'll see how that goes. And then it'll either come from the House to us or from us to the House. There'll be a significant amendment that'll be shared with everybody ahead of time to be looked over, which will be pretty much the effect of a conference report. So given the way times are, I think that's the most fair way to do it. So any questions about that? And then the second bill we're taking up will be heard and then laid over. It's my hope to move that to finance next week, so that those topics can be available for negotiations with the governor and the House, and hopefully solve some of the challenges we're facing. Any questions about that from members? Okay, and Kevin, you'll keep track for me. Well, very good. Let's take up Senate File 3322, and so we'll move that to get it in front of us, and then we'll take up immediately the 812 amendment, which is a delete all that's some 200 pages long. And this is largely an amendment that's familiar to the work of the committee. It's everything that we've passed to the floor, a lot of governor's bills, a few unresolved elements on Articles 4 and 5 with MnCHOICES, and then the rest. And so I would ask the staff, the council, if they would walk through that for us on a relatively high level. It'll be my intention then to sort out any questions about this base amendment, and if you want the department to come down, they're available to discuss any elements you like. And there's a few letters that are in the packets. Aspire, Foster Advocates, SMACSA, and Minnesota Association Committee of Mental Health Programs have all submitted written testimony, which I invite members to read. So without further ado, maybe I'll call on council to do their walkthrough, and then we'll go from there. Thank you.
Thank you, Mr. Chair, members of the committee. If everyone can hear me, I'll begin the walkthrough by summarizing or explaining Article 1, and then Mr. Monahan will explain Articles 2, 3, 4, and 5, and then I'll finish Articles 6 and 7. So if we're looking at the A12 amendment to 3322, Article 1, Sections 1 and 2, you may recognize from Senator Housley's bill, the House File 1883. This deals with foster care student enrollment and just requires enrollment of a student within 7 days if changing their school is in the best interest of that student. Article 1, Section 3 comes from SF 3430 from Senator Ralph and partially Senator Abeler's 3322, which deals with both the foster care fetal alcohol spectrum disorder screening changes and the foster care comfort call proposal we discussed in committee. And then Article 1, Section 4 is a direction to the commissioner regarding the development of training for the foster care initial comfort call. Article 2, Section 1 begins with language from a Senator Jensen bill, which would prohibit new or additional reporting requirements for mental health providers until their reimbursement rate is increased. And at this point, I'll turn things over to Mr. Monahan.
Mr. Chair, members, most of these proposals and the remainder of this article are bills that you've heard before. So sections 2, 4, and 5 are predominantly from Senate File 3117, which was a Senator Utke bill. These were the ARM policy provisions. There's also a piece of a DHS proposal that's in here because it was amending the same section of statute. So they were rolled together in this article. Sections 3 and 6 to 8 were a Senator Isaacson bill, 3177. This was a proposal to require sexual violence prevention training for the staff of waiver service providers and disability service providers. Sections 9 and 27 are new language. These are technical amendments to codify an existing grant known to most people as the Proof Alliance grant. It's for fetal alcohol syndrome services and education and public education purposes. The first section, Section 9, codifies the grant, and you'll see later in Section 27 what looks like a new appropriation, but it's not. It's just sort of rejiggering the way the appropriation is written to match the new codified language. Section 10 is a technical change to the spend down for MA. Sections 11, 20 to 21, 23 to 24, and 29 to 30 are from Senate File 3362. This was a Senator Utke proposal that codified the consumer-directed community supports language that was scattered throughout many years of session law. And then there's a number of accompanying technical changes to the statutes to accommodate that codification. Sections 12 to 13 are from Senate File 3291. This was a Senator Ralph bill related to PRTF modifications, some changes to the state medical review agent, and some changes related to the per diem per provider rates. Sections 14 to 19 were from Senate File 3834. This was a Senator Draheim proposal. It expands the upper age limit to 25 for, I'm going to have to defer to Mr. Oswald on exactly what this was. My apologies. Section 22 was from Senate File 3114, a Senator Utke proposal. This was a provision to require the Department of Human Services to use different standards of analysis of the absence and utilization factor within DWRS. Sections 25 to 26 were from Senate File 3061. These are modifications to the Birth to 8 pilot project. And finally, Section 28 is from Senate File 530, and this is a moratorium exception allowing eligible licensed family adult foster care to convert their license to either a corporate adult foster care or a community residential setting. That's the end of Article 2. Article 3 was heard in committee. It was Senate File 3782. You may recall this had two pieces. The first piece was to codify a number of policy statements related to education first, self-directed services, and living independently, and some other language related to those general policy statements, specifying how those should be applied to waiver services. Article 4 is predominantly taken from Senate File 4200, which was heard in committee, but not for the purposes of hearing the underlying language. You may recall that was the vehicle that was used for an amendment for the emergency authority that was to be granted to the Commissioner of Human Services. I'll spend some more time on Article 4, just highlighting some of the more important changes that are reflected in that language. There were a number of changes made to the assessment process, case management process, and the service planning process that providers go through, attempting to put into statute some of the changes related to those policy statements from the prior articles. So a lot of language around employment services, a lot of language about living independently, and a lot of language around self-directed services. I'll note that there were quite a few changes made to what are referred to as MnCHOICE assessments, or otherwise known as long-term care consultation services. Again, a lot of these had to do with aligning that process with those earlier policy statements, but there were also in here some changes to the process by which people come to have such an assessment. So Article 4, Section 4 restricts eligibility for long-term care consultation services to individuals who are either already enrolled in MA, determined to be financially eligible for alternative care, determined already to have a developmental disability, or have been referred to consultation services following a nursing home pre-admission screening. And it also further specifies that for those who are enrolled in MA, they have to either be 65 years or older, blind, or already have been determined to have a disability prior to being provided with their MnCHOICE assessment. Article 4, Section 5 has an exception to all of that language in the prior section that allows lead agencies to assess individuals who need PCA services using a MnCHOICE assessment, even if they don't meet the eligibility requirements in the prior section. I'm going to skip some of these others for the sake of time. I will say there's language in 2 different places in this article that remove the current law requirement that a MnCHOICE assessment be provided to any person who requests one, regardless of their eligibility for public programs. There's another provision in here that will permit an individual to forego a complete MnCHOICE assessment for up to 2 years, provided that in lieu of a complete assessment, the activities are performed that are required under federal law to maintain service eligibility. And then there's also some corresponding training requirements. So I will leave Article 4 there and move on to Article 5. I can, of course, answer questions should anybody have any. Article 5 is new language. It has to do with customized living, and it's a response to some reports that customized living services are being provided in housing with services establishments. And the fear is that that arrangement is circumventing the existing moratorium on foster care settings. So Article 5, Section 1 removes the authority of the Commissioner of Health to issue home and community-based services designations for home care providers who provide customized living services, but only if they're providing them under the BI or the CADI waivers. And it transfers that authority to the Commissioner of Human Services. Sections 2 to 5 make conforming changes. Section 6 requires home care providers providing customized living services under the BI or the CADI waiver to apply to the Commissioner of Human Services for a HCBS designation for each location in which the provider is providing customized living services under the BI and the CADI waiver. So just again to reiterate, lots of customized living services are provided under the elderly waiver. This language doesn't affect the elderly waiver in any way. And then subdivision 2 of section 6 establishes a moratorium on any new initial home and community-based service designations for new locations where customized living services have been provided, and that would be effective January 1. And finally, Article 5, Section 7 is a direction to the Commissioner requiring the Commissioner of Human Services to assess the use of customized living services under the BI and CADI waiver, particularly in unlicensed settings, and then provide recommendations to the legislature on how to, or if to, respond to services being provided in those settings. That's the conclusion of Article 5, and I'll hand it back over to Mr. Oswald.
Mr. Chair and members, if we look at Article 6, this is where the bill compiles selected policy proposals from the department's language. Beginning with sections 1 and 2, those come from SF 3799, which Senator Housley was the author for. Section 1 is an update to the statutory provisions relating to child care services grants, makes some clarifying changes, identifies the eligible programs, and authorizes a stipend for a review committee. It also replaces the maximum grant amount under those child care services grants from a maximum of $1,000 with an amount to be determined by the commissioner for each type of eligible program. Article 6, Section 2 is a clarification that the commissioner may waive CCAP requirements from the date of a declared disaster, and it amends the requirement for the commissioner to report which waivers had been made to the legislature within 5 days of the waiver happening instead of 10 days prior to the waiver being issued. Article 6, Section 3 is a modification to children's mental health respite grants. I believe it clarifies that the children receiving those grants do not have to be receiving respite services at the time the grant is issued. Sections 4 and 10 are provisions that clarify and modify child care center training requirements. Article 6, Section 5 removes 2 items from the list of exceptions to the moratorium on foster care initial licenses. First are licenses for transitioning individuals from PCA assistance to home and community-based services. And the second category removed from the list of exceptions are licenses for transitioning individuals from residential care waiver services to foster care services. Next, Article 6, Sections 6 and 7, Section 9, Sections 11 and 12 all include changes to provisions regarding family foster care. These include documentation requirements, staff qualifications, provider qualifications, and training requirements. All of those modifications from the policy bill from the department. Article 6, Section 8 is from the author's amendment that Senator Kiffmeyer offered to SF 4070. This clarifies a training exemption for a family daycare household member to be permitted to supervise a child to whom that individual is related without being trained as a substitute or a caregiver for the program, provided that the household member is only supervising the related child or children. Article 6, Sections 13 and 28 through 37 are modifications and clarifications to home and community-based services provisions. Article 6, Section 14 is a state-operated services provision that clarifies the criteria for terminating services for individuals with complex behavioral needs. Article 6, Sections 15 to 19 are updates to the withdrawal management program statutes and an additional requirement for license holders to complete a summary of comprehensive assessments and include that in the client's files. Article 6, next are Sections 20 and 21 and 24 and 25, which are modifications and clarifications relating to substance use disorder program requirements. It also relates to a set of services for individuals screened in for that type of treatment. Next, Article 6, Sections 22 and 23 are a permission for eligible child care assistance centers to continue serving children over the age of 13 and in certain circumstances. Article 6, Section 26 is a provision that removes a limitation on MA coverage for intensive mental health outpatient treatment. That coverage had been previously limited to adults, but that the proposal would remove that limitation to provide the coverage for all individuals, not just adults. Article 6, Section 27 is an authorization of the department imposing a fine for repeat violations by license holders of Chapter 254B or 245G. Next, Article 6, Sections 38 and 40 through 45 are updates to the housing support statutes and a provision that would authorize corrected housing support payments, collecting those corrected payments. Next, Article 6, Sections 39 and 46 through 47 alter the definition of a qualified professional for purposes of the general assistance and housing support programs. Article 6, Section 48 is a direction to the commissioner that requires the commissioner to evaluate the use of continuous licenses for family daycare providers and to supply legislation that would accomplish that for the 2021 legislative session. Article 6, Section 49 is an instruction to the revisor to exchange the phrase disability linkage line for the phrase disability hub throughout statute. And then finally, Article 6, Section 20 is a repealer that relates to revised foster care training requirements, as well as the definition of a qualified medical professional, both of which were altered by other sections in Article 6. Finally, Article 7, rather than entertain you with the details of all 124 sections, I'll suffice it to say that the whole bill comes from Senator Ralph's SF 2902, which is an overall update to the provisions governing civil commitment, which includes modernizing terminology, technical and conforming changes, clarifications of the existing provisions, replacing court-ordered early intervention with county-based engagement services, an expansion of the definition of a health officer to include all mental health professionals, and a distinction between a general examiner and a court examiner. As Mr. Monahan said, additional details and answers to questions are available should you need them, but that should complete the high-level summary that the chair requested.
Well, I very much appreciate that. Thank you. And I want to point out to members and the public that Articles 4 and 5 are still, I would not consider them complete by the least. The department is working on its technical assistance on those, and they're interested to chat. We're listening to their advice, and frankly, for this to move forward, there would have to be agreement by everybody. So any input people might have, in the public or whomever would be good to come to me and to them. And so we'll work on that. So having been to the walkthrough, any questions from members? See any hands? Okay, I don't see any hands. And so if there are any of those, Senator Hayden, it's like you're off the beach. And so you have an amendment, I believe, right?
Yeah, I do. Well, thank you, Mr. Chair. I'm actually at the Edmund Pettus Bridge in Selma, Alabama.
You get around, Selma, Alabama. You get around.
Mr. Chair, thank you. And thank you guys so much for doing this. I'd like to offer the A15 amendment.
Okay, and do you want to describe it or do you want staff to describe it?
Well, I have some talking points, and if staff, if people have more questions, maybe staff can help me. The A15.
Well, go ahead. I'll just announce that you've moved the A15 amendment, and so Senator Hayden to your amendment.
Well, thank you, Mr. Chair. Members, A15 is Senator Marty's bill SF 3579. 3579 is a bill that extends the expiration date for a study called Baby's First Year, which is currently being conducted in Minnesota on the impact of a monthly cash gift to a family on child brain development between the ages of 0 and 3. The legislation enabling the study to be conducted was passed in 2016 with bipartisan support. The 2016 legislation excluded cash gift from the families from means-tested programs for the length of the study. Minnesota was picked to be one of 4 sites across the nation to participate in the study funded by the National Institute of Health with Dr. Michael Giragolf, if I pronounce his name right, of pediatrics and neonatology at the University of Minnesota. He's at the University of Minnesota, an expert in infant brain development and neurocognitive functions to oversee the collection of neuroscientific data. There's no cost to the state for the study. Mr. Chair, members, unfortunately, it took some time to get the study up and running, so the expiration date is to be extended. SF 3579 extends expiration date from exclusion from January 1st, 2022 to January 1st, 2026. So it just essentially is a study, and it's no cost to the state. We did some legislation on this, and we just want to extend this out to 2026.
Yeah, sounds like a good idea to me. And by the way, I was wrong looking for hands. If members, you don't have to raise your hand. You actually could just, if you want to raise your hand, if there's a whole bunch of people, we'll do that. But Senator Benson, was your comment to this or the previous bill? We'll come back to it.
Well, I have a question to this, and then to the rest of the bill. So Senator Hayden, is the NIH grant still ongoing, or are we funding the research at the state?
It's my understanding, well, thank you, Mr. Chair and Senator Benson. It's my understanding from Senator Marty and the advocates that there's no cost to the state. We're just enabling the means testing portion of this to extend to 2026. So they're getting extra money in order to look at this issue, and we passed legislation in 2016 to not allow this be means tested. In other words, to be on top of what they get if they're getting public assistance.
Senator Benson.
Thank you, Mr. Chair. I just wanted to know if we're still getting the NIH money, if we're still continuing this research. So I think that's a follow-up question. It doesn't sound like, Senator Hayden, this was originally your idea. This was a Senator Marty idea. So I think I'll need other follow-up, or maybe council knows as they went through the process. But if somebody does, I'd appreciate knowing. Thanks.
Well, Mr. Chair and Senator Benson, I am getting a text in from the advocates that said that the NIH is continuing and that it's ongoing. So that's the answer to your question.
Thank you.
Any more questions to this amendment? And Brittany, I forgot, how do we vote? Are we gonna, do people vote and then we just take an audio vote, or do they have to raise their hands?
Mr. Chair and members, so the procedure that's been recommended for voice votes is that members turn on their video. When Mr. Chair calls for the ayes, you verbally give your vote as well as a visual cue, so a raise of a hand or a thumbs up. And staff, as well as Chair Abeler, will keep an eye on the video feeds for the members. And then when he calls for the noes, same thing. If there is a question, if the chair is unsure or a member calls for division, we would then go through that process. But that's how we've been advised to do voice votes.
Super. Everybody understand that? So we're going to vote on the amendment. All in favor of the 815, say aye. Aye.
Aye.
All those opposed, I guess that'd be a thumbs down sign on that would be. All right, well, the thing, the motion prevails, amendment's adopted.
Thank you, Mr.
Senator
Chair,
Benson, you have
members.
something else? We're going to take up, we're going to take up an amendment with the technical advice from the department on some stuff. Do you want to take up did you want to speak now, Senator Benson, or wait till that?
Mr. Chair, I did have some questions as to whether this has fiscal cost, because it looks like we're asking the department to do quite a bit. And then on Article, let's see, I'm trying to find on Article 3, you had some policy statements, and I understand and support the policy statements, but it doesn't appear there's any sort of fiscal limit on how we assist someone with independence. And so I'm wondering what the fiscal implication of that policy statement might be, if you could talk about that. So does this bill have any cost to the department? And then does the policy statement then shift us to a different format?
Thanks, Senator Benson. I can help with part of that, and then whoever is going to speak on behalf of the department about fiscal matters, I would like to have them be available for the next comment. Articles, all the articles except for 4 and 5, to my knowledge, have no fiscal impact. There's a possibility, yet uncertain, that there might be some impact on Articles 4 and 5 while we get the technical advice. If it turns out there is, those will disappear from this bill. And that's being worked on along the way to the floor. And so this is a no money bill. That's my assertion. And so there were a couple items that people wanted to put in here that had some fiscal impact that are themselves now going to finance. And if it turns out that they're without cost, they might be re-added as the floor amendment. It might be a substantial floor amendment. Hopefully pre-con for read is the plan. So who from the department can comment about the fiscal status of this bill, please? Maybe just start talking, I guess.
This is Elise Bailey.
Yeah, welcome to the committee.
Hi, thank you. We do have a few items that we believe may have some costs in the bill. The item that Senator Benson brought up, as far as like the policy goals, we do not believe has a cost. But there are some items that we're working through that we will get to the committee on whether we believe there is a cost.
Senator Benson.
Mr. Chair, it's very hard for me to pinpoint. This is 198 pages of interwoven policy, and so it's very hard for me to tell as we redirect the department to do things or to extend access licensing. It's hard for me to tell if there's a fiscal impact or not. I just want assurances that we're not going to get to the floor and have to have this recalled to the Finance Committee.
And Senator Benson, you and I agree on that. So we will keep members apprised about that. So it's meant to be without any cost. If that's helpful. Mr. Burdick wanted to comment. Mr. Burdick, do you want to comment after we take up your technical advice amendment, or at this time?
Hi, Mr. Chair. We can comment after you take up the technical amendment in case there's questions about that.
Okay, any more questions to the bill?
Senator Ingebrigtsen.
Yes, Senator. Welcome to the committee.
Yeah, listen, I apologize for being late. I didn't get, I think, to hear all of it.
We could repeat it for you if you'd like. It's really an interesting bill.
No, that's all right. No, I'm good. The bill that I was wondering about, and I've been called about, is that bill that Senator Udke had for life right. I don't know if you remember Douglas County. Is that included in this bill? I guess I should know that, but I don't.
So yeah, it's going to be included after it gets through with finance. There was a potential of it being. It's probably neutral, but it affects money somehow. And so finance is hopefully going to hear it. When it comes back as no net cost, we can add it back on the floor. That's what I understand. Is that correct, everybody, staff? I think I said that right. So,
thank you.
Any other questions about the bill? Let me move the A22 amendment. And then I would like staff to walk through that. And then Mr. Burdick is available for questions, as is a whole plethora of other staff. So if you want to walk through that, please, Council.
Thank you, Mr. Chair and members. If members will pull up the A22 amendment, Mr. Monahan and I will go through a line-by-line walkthrough of the elements of this. So if you look at the A22 document, we start with lines 1.3 through 1.13, and those lines would add a parallel provision to the existing or the proposal that would bar the imposition of new or additional reporting requirements for community-based mental health providers. The language that was included in the base DE amendment was limited to adult mental health services, and the original intent of the proposal was to capture both adult mental health services and children's mental health services. So lines 1.3 through 1.13 would simply add a parallel prohibition identical to the one in the existing bill.
Mr. Chair and members, on 1.14, there's language clarifying when the 45-day planning meeting must occur for folks receiving services provided or licensed under 245D. My understanding is this was part of an agreement between the department and ARM. And the next two lines, 1.15 and 1.16, are just technical, grammatical, and spelling corrections.
Mr. Chair, members, the next group of changes are lines 1.17 and 1.18, and this relates to the codification of the Proof Alliance grants, and this just rearranges where the reference to tribal governments appears in that language. It's just a technical rearrangement of the words. It doesn't carry a substantive effect. Next is lines 1.19 through 3.4 in the amendment, and this proposal would add language from a Senator Rosen bill that was introduced and discussed quite a bit last session about services that are referred to as a yellow line program for officer-involved community-based care coordination. The content that would be added here is just the policy changes that rename those services and then incorporate provisions about how those services are provided by tribal organizations. But importantly, if you look at lines 3.1 to 3.4, the introduced language eliminated this paragraph F, which would have eliminated the county share and carried a fiscal cost. That is no longer happening, so that makes this proposal cost neutral and can be included in the policy bill.
Mr. Chair and members, the next set of changes are on page 3, line 5, all the way through page 5, line 20. I should perhaps pause here and say that this amendment Senator Abeler is regarding as an author's amendment. Much of this language is the result of DHS technical assistance. This particular proposal isn't. This is new, but it would allow advanced practice registered nurses and physician assistants to order home health services under medical assistance, which is something only physicians may do under current law. And this change would bring the MA requirements for ordering home care into line with the recent permanent changes that were made to Medicare requirements for home care that were found in the recently enacted CARES Act.
Mr. Chair and members, looking at lines 5.21 to 6.1, these changes are the result of technical assistance from the department, and they're tied to a proposal from Senator Draheim bill that would have expanded the age range for children's mental health crisis services. We were informed, the department informed us that including that age range expansion, but not adding new money is not possible because this is an MA benefit, and to expand that program would carry a fiscal impact because it's a forecasted program. So this section of changes would simply eliminate the age range expansion piece, but leave in place a few other portions that amend some service standards and a few other technical clarifying changes to those sections. So it would eliminate anything that would carry a cost for that proposal. Next, lines 6.2 through 6.5, they simply add an immediate effective date for the birth to age 8 modifications that I believe was agreed to when that bill came up and passed out of the HSR committee. Next is line 6.6 through 6.8. This is a parallel provision also from the department's technical assistance that adjusts the reference to tribal governments in the Proof Alliance grants. Line 6.9 is just simply another correction of a typo that we found in the bill.
Mr. Chair and members, 6.10 to 6.11 is technical assistance from DHS helping to clarify the date by which eligible foster care homes that are currently licensed as adult family foster care may transition to adult corporate foster care or to a community residential setting.
Mr. Chair, members, next is line 6.12 through 6.16. This is also technical assistance from the department. And these lines would remove the sections of the DHS policy bill that related to modifications of family foster care documentation, training requirements, because those will require resources that aren't available due to COVID-19 and other needs that the department is meeting. Next, line 6.17 through 6.21. This is more technical assistance from the department that corrects some phrasing that that would have implemented an exemption from statutory requirements for clients receiving substance use disorder treatment. but that should be corrected to have that exemption from the requirements apply to the providers of the treatment, not the clients receiving the treatment. So it's just a rephrase of that language to make that flow properly. Let's see, next 6.22 to 6.23 just removes an unnecessary sentence from the end of a DHS proposal.
Mr. Chair and members, the next set of changes in the amendment, page 6, line 24 through page 8, line 15, is DHS technical assistance. It's our understanding that it reflects an agreement between the department and stakeholders regarding DHS's proposed changes to the EIDBI services. And the language is identical in substance to an author's amendment that was drafted to the House Companion, but was never offered because the bill was never heard because the committee stopped meeting.
Mr. Chair, members, next is lines 8.16 through 8.20. This is more TA from the department that relates to the language that alters the definition of qualified professional for the general assistance and housing support program. And this just removes a limitation on the definition of qualified professional that had limited the definition to physical illnesses, just removes that and expands it to include all illnesses, injuries, or incapacities. It clarifies that a qualified professional, be it a physician, physician's assistant, nurse practitioner, physical therapist, etc., their qualifications would depend on each of their field's scope of practice. And then it also deletes the reference to physician's assistants in the definition of qualified professional for mental health matters. Next, lines 8.21 through 8.23 adjust the repealer in Article 6 to remove the sections regarding the foster care provider training modifications, because the amendment would be removing those changes, so the repealer would be unnecessary. And then finally, lines 8.24 through 8.25 removes a limitation from the civil commitment proposal, and that limitation would require an examiner to be practicing in an emergency room at a critical access hospital. This change would remove the limitation to critical access hospitals and expand that definition to allow an examiner to be practicing in an emergency room in any hospital, provided that the hospital has the appropriate processes in place to qualify those individuals to serve as an examiner. And that completes the walkthrough of the A22 amendment.
Unmute, okay. Senator Uckey, did you have a question?
Yeah, thank you, Mr. Chair. And this is actually probably for staff, but I had in my original documents that were sent the A21 amendment, and then we did get follow-up that A22 is the new version, but just confirming that everything in the A21 is in the A22 and that we don't need anything from 21 anymore. And I guess maybe staff would have worked on that so they could help us out.
Yeah, please, staff, if you want to comment, the council.
Sure.
Go ahead, Pat.
Mr. Chair and Senator Utkey, yes, the A22 includes everything that was in the A21. It just adds the only piece that was added in the A22 is at line 6.2 through 6.5, adding the immediate effective day or effective date following the changes to the Birth to Age 8 program, which had been discussed and agreed to when that bill was passed out of the committee.
Thank you.
Okay, good. Mr. Burdick, did you want to comment now or after we adopt the amendment?
Thank you, Mr. Chair, whichever you prefer.
All right. Well, let's just adopt the amendment, and then Mr. Burdick can have his comments. And any other questions about the A22? I might go in. Okay, seeing none, somebody else. I don't know why I'm getting feedback, but anyway, seeing none, all in favor of the 822, say aye and give a thumbs up.
Aye.
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 All opposed? Anybody? All right, the amendment's adopted. Thank you. Mr. Burdick.
Great. Thank you, Mr. Chair. For the record, Matt Burdick with the Department of Human Services. It's great to see all of you virtually. Just want to start off by saying thank you. We really appreciate that you included many of the really important provisions from the DHS policy package in Senate File 3322. These are really important both for the department and for our partners so that we can effectively deliver services, and we're really just grateful to have those in the bill. I do just want to quickly acknowledge we've heard some feedback and concerns from AFSCME and disability advocates on the MnCHOICES language in Article 6, Section 14. And we've been having really productive conversations over the past 48 hours and believe we're very close to language that everyone can be comfortable with, and just want to express our commitment to getting that resolved before this is all wrapped up. As you continue to work on this bill with the other body, we'd just like to ask for consideration about a couple of the items that were not part of this agreement, but that were heard in the committee, and give you an update about where we're at with some of those. We feel that these are some of the really critical things that we need to get done this year to make sure that we can continue some important pieces here. One of the big ones I want to touch on is establishing standards for qualified residential treatment programs, or QRTPs. This was Senate File 4106 that Senator Ralph had carried. This is the language that we need to bring Minnesota into compliance with the Federal Family First Act and ensure that counties can continue to obtain Title IV funding in certain settings. We've had a lot of conversation with stakeholders about this, and we think we're very close to getting to consensus on that. And we'll keep you updated on that and want to have continued dialogue with the committee. Another big one is the child care licensing standards. This is from Senate File 4070, Senator Kiffmeyer's bill. This language really is necessary to bring us into federal compliance and avoid some financial penalties. We are working to refine this language to be very clear about what is truly required under federal law, and also to make sure the legislature has really clear insight about where the federal law gives the state a policy choice that needs to be made, and so that can help inform decision making. And we will be following up with committee members about that in the near future. The other item we want to mention is extending the Cultural and Ethnic Communities Leadership Council, the CECLC. So Senate File 1561 under Hayden's bill. That council is currently set to expire this summer, and so we think it's really important to life of the council and so they can continue important work. Lastly, we have Senate File 4104 under Ralph that deals with child support, and these are provisions that address things like federal compliance, conflicts within current state law, and some tribal sovereignty issues. And we think they're important to get done, and we've resolved any stakeholder controversy. Lastly, I'll just note for the record that, as you noted, Mr. Chair, we do want to continue conversation about Articles 4 and 5, and just appreciate continue to have dialogue about those. So with that, thank you. And myself and the rest of the DHS legislative team will be on the line for the remainder of the hearing if there's questions about this bill, or if we can be helpful with technical guidance as you continue with the agenda.
Thank you, Mr. Burdick. I see some more Zoom calls coming up to talk about some of this stuff. So, and just to the community at large, I don't imagine this is a perfect product yet. Particularly if you have concerns about something, if you're, the counties or providers, it's really clunky these days corresponding, but it's a good idea. And so if you're going to write, write whatever legislator you want to, but include me if you like, and maybe we'll include our council and see if we can find some way to sort these things out, because we want to get to a consensus, and we want to get this bill to actually be substantial and accomplish the good work we're to do. Any other questions or comments to this bill before we move to a vote? Senator Hayden, are you waving your hand, or you're just kind of wiping off the?
No, I just.
Was it raining by the bridge there or something?
Yeah, it was getting a little. The storm was coming through. I mean, I know that's coming from Senator Uckey's island, but no, I just have a after we get through with this bill, I just want to ask a couple of questions before we sign off. So not.
Yeah,
not
we're
to
doing
this
one
bill.
more bill after this, so good.
Okay.
Senator Abeler.
Yeah, and we do have a hard stop at 4:30. Who else said something?
Senator Isaacson.
Oh, Senator Isaacson. Yeah, hi.
Did I just hear you say that the language that was left out had to do with that council that's going to end this year? Did I hear that correctly?
It was, I don't know if we didn't. Yeah, I think it's fine. It just got, I don't know why it wasn't in. Did we hear it? I don't even remember.
It was
so
Senator Hayden's bill,
those are,
and I think I just heard him say that it was not included in this bill, and I'm wondering.
It's not included in this bill for, I don't even know what reason. I'm friendly to it personally, so I don't see any reason we can't put it back in on. But then the plan going forward, we have to move something, and so we put everything in we could think of. And so there's going to be a substantial amendment on the floor, which will be noted to everybody and pre-confereed with the House. So I would think that bit of language is going to be alive and well.
All right, perfect. Thank you.
From my point of view.
Yes, sir, Mr. Chair.
Senator Hayden.
Yeah, I would hope. I mean, we don't have to do it today, but I think it's a pretty. We did hear the bill and had a little bit of conversation about it. I know Representative Moran is going to have it in the package that she has. So hopefully, when you pre-conference it gets together and gets in. It's just simply an extension or elimination of the sunset for a group that's doing pretty good work.
I think if I were a gambling person, I would vote that it's going to be in the product. So, so anything else?
Mr. Chair.
Senator Bingham.
Thank you. Real quick, just more of a comment that I think I'm going to include you, since you just said this on an email, that I think the county attorneys still have some concern about the language with the foster family phone call. Just I think it'd be good to hear them out on just that, some technical things and getting some clarifying intent, if you will, on how these calls would go. And so I appreciate at least maybe you guys having a conversation as we move through this process. Not that the overall concept is bad, but how it's implemented and how it may impact some of the decisions that come down in our courts is important. And so if you don't mind, I might include you on that.
Well, and then Senator Bingham, that's what we call the comfort call. So that's to be worked on, and that the department has advice, and the counties have some thoughts too. So that's still in the loop. So please, if you want to engage on that topic, I think include Senator Bingham with whoever's working on that. So I want to move.
I appreciate that. Thank you.
All right. Anybody else? Okay, seeing no other comments, I'll renew my motion that Senate File 3322 as amended be recommended to pass and be referred to the general orders. Everybody understand that? All in favor, say aye and thumbs up.
Aye. Aye.
Opposed? All right, that's done. And Senator Hayden, did you want to? We have a half hour to finish to get going on the money thing. But Senator Hayden, did you want to offer a comment now about something?
Oh, well, yeah. Well, thank you so much, Mr. Chair. I didn't know if in our upcoming schedule, and I know this is a little more COVID related, and so I'm not sure how those. I know that we're in kind of a new era. The COVID work groups. I don't know if they're going to meet again, but I know that we had some discussion in the leadership on the one-time $500 MFIB TANF out of the TANF block grant, and didn't know if we plan to do any more work on that. Maybe Senator Benson can help us too. I don't know if Senator Rose is on this call. She's not on the committee anymore, but just didn't know if that if this is an appropriate stage or if it's going to be just more of the broader leadership conversation. So I just wanted to raise it.
Well, I can comment about my thoughts, and I supported it at least at one point, and I'll just tell you my personal concern about it. And it's not negative. It's not before us now, but I'm concerned that next year is going to be pretty horrific. My number in my head is $5 billion deficit, and I don't know how close I am, but I'm afraid I'm not that far off, at least in terms of a large number that we're just going to be terrified by. And it may well be that the $13 million that has would be really nice to have handy for next year while we try to fill some holes we don't even know exist. So, and so if beyond that, the leadership, it was on the table there. So that's the best I got, and that's my true answer to you.
Okay, Mr. Chair, yeah, that's good. I just wanted to, I think we all, know that, there's a lot of hardship out here. We don't need to take our time up going over that. We hear about it each and every day. We talk about it on the floor, and you see it every day in the news. And just wanted to make sure that those folks that are at the lowest end of our spectrum are also facing those hardships. And often those folks, if we, get to the surge and anticipate that, there's just a lot of talk from city to city to city. I was on a couple of large national calls, one yesterday and one today, in which people of color in particular and low-income people have been ravaged by the virus. And so certainly just want to make sure that we keep them in mind as we're thinking about relief packages for all Minnesotans. So thank you so much, Mr. Chair.
Yeah, for sure. So let's take up the Senate File 3694. The intent is to go through it and then hear some testimony and have a few conversations. We're going to have to kind of move. And so if staff could give a really high level overview, I'd like to have, we have several testifiers, and I'd like to give them, at this point, 2 minutes is going to be luxurious. So the other bill took just, you never know how long it takes to take online. It just took a little longer, I think. But so if staff wants to go over the highlights, maybe a 5-minute rendition of what the, I'll move the A2 amendment, what the A2 amendment is, please.
Mr. Chair and members, I think I can probably do it in less than 5 minutes. Section 1 of the amendment is the underlying language from the bill. It just corrects a drafting error from last year having to do with a 90-day notice from the commissioner to lead agencies regarding which form they have to use for PCA assessments. Section 2 would be a temporary suspension of the department's authority to collect parental contribution payments for families participating in the TEFRA program. And then when the peacetime emergency ends, the department may resume collecting the parental contributions, but they also need to do their normal redetermination of a household's payment if they report during the time of the suspension that their income declined by more than 10%. Section 3 is a temporary change to the way in which NEMT providers would bill for assisted transport. It allows them to bill the commissioner directly rather than going through their local agency. Section 4 is a temporary 50% rate increase for NEMT providers. Section 5 would establish an appropriation for additional funds that the Commissioner of Human Services could use to pay NEMT providers to provide additional non-transportation services, or not their normal non-emergency medical transportation services. So doing things like perhaps delivering prescriptions or delivering food through a partnership with food shelves, those sorts of activities. Section 6 is a retainer payment to certain providers of day services and employment services under the disability waivers, adult day services under the elderly waiver, children's therapeutic supports and services, and early intensive developmental and behavioral intervention services. The retainer payments would be initially equal to 50% of the past revenue for the eligible services, and then those payments would be reduced after a period of time to a lower number, depending on whether or not the provider is able to provide and bill for services that are provided under some alternative set of standards than those that are currently required. And the retainer payments in the current draft would also be subject to a payback provision if other funding sources became available to the providers, and it would also treat a failure to repay as an overpayment and permit the department to recoup those costs under their existing authority for overpayments. Section 7 is a temporary rate increase for PCA services, and furthermore, a requirement that providers that receive increased revenue as a result of the rate increase use 80% of the additional revenue for wages and associated employer costs like taxes and so forth, and then use the remainder for sanitation and personal protective equipment and other measures to conform with the CDC recommendations. And finally, Section 6 is a similar provision, a 15% rate increase for certain HCBS waiver services, including certain residential services and certain employment services. And it has similar provisions about using at least 80% of the additional revenue for wages and associated costs, and the remainder for sanitation and the purchasing of personal protective equipment. And that concludes the summary of the A2.
Well, and thank you very much. The challenge that this bill is attempting to face, in particular, well, there's a number of nuances to it, but especially to keep the industry open until when this whole COVID thing has worked its way through. There's some very real risks that a bunch of these providers of all sorts are going to be closing their doors because they can't afford the fixed costs. And I should tell the people listening that we're bringing it forward here because we would like to do this. This is not a done deal by any means. This is, I think, the Senate in a bipartisan way pushing the leadership and whoever to pay attention to this, because this is a grave issue. And so the people listening who hope this gets done would do well to remind the governor that they care about it, the various commissioners, in particular DHS, tell the leadership of the House and the Senate, everybody, that this is something really worrisome. So just since time is running like it is, I think I'm going to get the amendments out of the way. So Senator Hoffman, I know, has an amendment. And so if you want to bring up that would be good. Go ahead, Senator Hoffman.
Thank you, Mr. Chair and members. I think it's the A3 amendment, Brittany. And what I basically am doing is simply changing the language from revenue the provider received for eligible services during January to revenue the provider billed for eligible services during February, rather than looking at December, because December is really a weird month to be looking at because it doesn't show a full spectrum of services that are available. And the second desired change would be to remove the word philanthropic, because most of the dollars that come to the programs that we're talking about are all state dollars mostly. So it's very difficult to separate the philanthropic funding due to the COVID virus and other purposes. So that's my simple amendment. Thank you.
Any questions to the amendment that people want to ask about? Not seeing any. So, Senator Benson, do you want to ask a question about this amendment or about? I'm sorry, it's so weird to see people. I don't always know what people asking attention looks like.
It's the bill in general, so I'm trying to get to where the language would be. So I'm sorry, Senator Hoffman, what's the actual impact? I'm going to try to keep jumping back and forth. I should have printed all of this that the provider received.
So it's, and actually, Senator Benson, part of why this bill is not moving is this whole topic has to be fleshed out a bit more, because what we haven't gotten sorted out is the interaction with the federal money and the state. And so both sides, both groups want the other to go first, and then they'll pay what's left. And so we don't want to hamstring, we don't want to give somebody some money and then they can't get some other money that was already available. So that's why the bill is being held over in particular, even just to move it, to take it to finance, let them sort out that. We're not even close enough to a bill that I would feel comfortable sending there for them to even begin to consider. Does that help you? And so it's a bit of a work in progress, which I'm sure you love that phrase.
Well, it just, I'm not sure when this showed up in my inbox, but this is fundamentally different than the underlying bill. So I'm glad we're not going to move it. So Senator Hoffman, I guess I'm still trying to figure out what your amendment does, but given that we're going to spend a significant amount of time between now and when it passes, just trying to figure out what.
If you don't mind that for now, this is going to be laid over. So just given the time, if you don't mind, I think it's a longer discussion than we can do here.
Yeah, Mr. Chair, it looks like the Hoffman amendment takes out philanthropic, so that if the provider received any philanthropic money, it wouldn't be applied. That's just one part of what the amendment does. And why would we do that?
Senator
Why
Hoffman.
would we say if the Minneapolis Foundation gave somebody $1 million, that shouldn't be provided back?
Senator Hoffman.
I'm not sure.
Thank you, Mr. Chair. Good question, Senator Benson. The programs that we're talking about are those HCBS providers that the majority of their funding comes from the state federal match. Hence, that's why we're trying to go forward with the formulary dollars that the state appropriates, not necessarily the federal 1135, 1113s, or whatever version they have to go on. This specifically addresses to those day programs. Like, for example, this morning in St. Cloud, there was an article about how Wacosa and Rise is going to be just devastated because of the fact that we're not addressing this. And the day after is what we're trying to address in this whole bill. And that amendment specifically looks at the fact that the majority of those providers are getting their dollars from that state federal match, and there isn't really a high amount of philanthropic dollars involved. So that just, it was unneeded language at the beginning.
So, Mr. Chair and Senator Hoffman, so if they had a fundraiser and raised money, that money wouldn't push back then Minnesota's general fund contribution?
Mr. Chair and Senator Benson, that's a good question. And no, the answer is not. This is specifically the state dollars that we throw in and the one-to-one match to the federal dollars. We're only isolating the state dollars on this conversation.
Senator Benson, does that help you?
I think it makes it worse. So,
okay.
You know.
Well, let's just let's get the bill how it is for now, and then we'll take it up, and you can sort through all this.
When will, Mr. Chair, when will we be reviewing this bill? Will we have a fiscal note?
I hope so. But let me just back up to the intention of the bill. We're in the middle of a real crisis, and I don't know if the fiscal note will be available. What I hope to do is to get the policy language in order and send it out to finance so it can be available there in the event that the leaders decide they want to do something about this, so it's had some kind of a process. And before they did anything, of course, it would be fiscal noted. It may well be that I'm going to urge us to, or at least suggest that we move this bill out next week with some incomplete fiscal connections.
So, Mr. Chair,
Senator,
do we move it out of this committee next week or move it out of finance next week?
No, move it out of this committee just to get it to finance, so it'll sit there and be dutifully looked after. So are members comfortable voting on the Hoffman amendment at this point? Anyway, something has popped up on my screen. I can't even see any of you anymore. So how's that? Anybody have any questions about it? Just say something if you do. Senator Isaacson.
I'm still trying to wrap my brain around it, and I'm certainly not comfortable voting on it at this point. I'm not saying it might not be a good idea. I can't speak as intelligently as I'd like to about that as I'm learning, but definitely don't want to send something someplace else if I don't feel like I have a good understanding of it. So.
Instead of, we have 12 minutes left to hear a bunch of witnesses, and I'm sorry this amendment's been so problematic. At this point, I'm going to suggest we lay the amendment over and hear from some testifiers. this whole bill is going to be taken up next week, I hope, in a way that can be made, possible. And I'm not interested in jamming an amendment through that at least two members have concerns about. So this is all, actually, just so you know, my personal opinion, a couple of the bills we've worked on have had less attention than this stuff has had, even as little as this has been by all of us. So I'm glad at least we're having a committee hearing about this. So do you have that testifier list? So we have some testifiers who I'd like to give a chance just to comment about the fix that we have. And I'm only going to give you 1 minute to go. And I'd like you to comment on what you think of our suggestion, or if you have a suggestion of what we forgot. And then we'll try to wrap it up at the end with some kind of a soft landing here. So, and Miss Bang, I think you're up first. Can't you open it?
Hello, can you hear me?
Yeah, and you only have 1 minute to comment about the PCA increase and what you think of it. So what do you think of it?
So I think it's necessary and needed. I'm sorry, my name is Peng Bang, and I am a board director with the Minnesota First Provider Alliance. I also own a PCA agency. I just wanted to say that real quick. And then, so I have caregivers right now who have second jobs. And part of the concern is that a lot of them are losing the income from their second jobs. Or I have a PCA who was sent home last week from his other job because his team, somebody on his team contracted the COVID-19. And so he's been sent home to quarantine for 14 days. And while he's quarantining, we're frantically trying to find caregivers to fill in his spot. And the rate increase would definitely help in that we could pay an existing PCA some overtime money because we're gonna,
okay.
Now we're asking.
Thank you. That's all. That's
okay.
Okay. I'm sorry. Time is so short.
No.
And Brittany, who's the next one on the list? I can't. This dried up on my software here. So.
Mr. Chair, after Ms. Bang, I have Mr. Nichols from the Minnesota Autism Center.
And then who's on deck, please?
Mr. Stahlberger, who I apologize, I misspelled his name on the agenda, so
yeah.
I'm sorry about
Mr.
that.
Mr. Nichols, go ahead. You've got a minute.
Yes, thank you. Hopefully you can hear me. Jeff Nichols, CEO, Minnesota Autism Center. Just high level and overall critically important bill. I can absolutely appreciate the senator's concerns about payback and frankly the fiscal impact on the state. What I'd say just from a high level though is these are monies that should have already been appropriated. In our case, it might have been some, as my illustration of my written comments, 1.7 million in fees that already we've not been able to bill, and that number continues. We're able to pivot some of our services and bill for a small percentage of what we were just a few short weeks ago. And we're continuing to try to turn the ship and keep the ship afloat. But we continue, frankly, as I speak, to lose $15,000 to $20,000 a day. So something needs to happen, short term and long term, or quite honestly, we will not be in business likely long term.
So, Mr. Nichols, are you covered in the legislation that we have in front of us?
Yes, the retainer payment portion of it, I would
and
suggest.
Do you like what you see there? If it could become law?
Yes, generally speaking, with the exception, as I point out in my written testimony about the concern about the SBA loan and how that all interacts. So if that could get
we have to sort that out.
Further conversation, yeah.
Mr. Stahlberger.
Thank you, Mr. Chair. I'll make this quick. Hopefully you can hear me okay. Thank you for your time today. I won't go through all of my testimony. We can maybe talk about it next week. For those of you who don't know, Phil Stahlberger, Vice President of Public Affairs for Medical Transportation Management, or MTM. We work with 14 counties in Minnesota, basically going from Dakota County up to St. Louis County, Cook, and Stearns County, Central Minnesota, et cetera. The work that we do, working with transportation providers around the state of Minnesota, we do recognize the fact that these providers are doing a valid service, and we need to reward them. especially regarding COVID-19 related trips. One of the things that we have at MTM is we have technology that we were actually able to identify COVID-19 conversations with our call center staff prior to this being a huge epidemic. So with our county, with the county consortium that we work with, we were actually able to identify some of these trips before this was actually an epidemic. With that, we worked with our transportation providers, those that were willing to transport members with COVID-19. We actually were able to make sure that they had enough PPE to take these trips. We do recognize that some of that does fall on them in terms of cost. We did provide as much as we could. I believe DHS did as well. So we recognize that these transportation providers are key to the success of the NEMT program, and we would support any type of increase that we can give them. With that, again, I'm just going to cut my testimony pretty short.
Well, good, because you're done. That's how short you get to be. So
done. Great. Thank you. Thanks for your time.
Yeah, and thanks. What were you going to say? Huh? Rob, you're next, please. Welcome to the expedient area. So,
yeah,
Mr. Rudlick, welcome to the
chair,
committee.
members
Like you're in a really nice place.
Yeah. Yeah.
Go ahead.
Big island in the background. My name's Rob Woodlick. Those of you who don't know me, I'm a quadriplegic and MnCHOICES board member and Get Up, Stand Up, Cure Paralysis board member too. This was PCA rate increases was in our top tier for policy increases regardless of the pandemic, but right now it's very critical. My care company shut down operations.
Okay, Mr. Woodlick, I don't have, we know the problems. We're trying to consider how our fixes are. So if we passed our bills, would that help you?
Yeah, they would.
Okay,
definitely.
That's what I want to hear. And I'm sorry, I
at a
mean, I've
minimum.
got like 4 minutes till we go dark. So
You go for it. Yeah.
thank you. Well, Ms. Howe, if you'd like to go and tell me how you like what we're trying to do, or did we forget something? I guess you get 45 seconds. So it's the island,
my
the big
name
island's
is
going to
Deb.
sink. Welcome.
Okay, thank you
All
so
right.
much, Chair. My name is Deb Housey, and I'm a home care worker on behalf of my union, SEIU Healthcare Minnesota. I do important work keeping our most vulnerable in our homes and communities. We need more money for paid leave, overtime, and PPE. If this does not happen, the care crisis that we are already experiencing in home care will get even more worse. So
And I'm worried about that. So you hope that we can pass the 15%. That would help, right?
yes, sir, it would. It would very much keep people
You want to do me a favor? Get everybody you know to write the governor and write the Speaker of the House, the Majority Leader of the Senate, and every chairman you can think of and every legislator and say, please keep us serving people in homes. It will help. We need that kind of pressure. So God bless your work. I'm so happy that you do what you do.
Thank you so much, sir.
Ms. Granados, yeah. Hi. Are you there?
Mr. Chair, she is not going to testify today. So that was a change in the agenda.
Okay, Mr. Ansom, or Jen Ansom, please. Are you there? Are they still on?
Hi, I'm a 39-year-old with muscular dystrophy. I receive 24 hours a day of PCA services. My PCAs are my lifeline to my life. And aside from my personal cares, when I become sick, they also become my respiratory therapist. As was the case this winter when I received bacterial pneumonia, I was able to avoid spending many weeks in a hospital. During COVID, the importance and significance of my PCAs increases tenfold, and they are risking their own lives and their safety to come take care of me and protect my health. And they run my errands in the community because getting sick with COVID would kill me due to my respiratory failure. But if my PCAs get symptoms of COVID, they cannot come to work, which is a financial loss for them. PCAs do not currently get sick pay, so it is imperative that the bill include the benefit of sick pay. Also, when a PCA is out of work for 2 weeks, that means it's additional strain on my other staff to cover the 24-hour care that I need. And right now, the PCAs are not reimbursed for overtime.
Yeah,
since
so
there is
I have to stop you. So you like our fix? Do you like the 15%?
yes, I fully support the 15%. It's
Okay.
vital to the client's well-being and the PCA's well-being during the COVID.
Thank you. I've got a minute and a half left, and I just wanted to comment on one thing. We're going to take this up, I think, next Wednesday and work on it some more. I just apologize for the race to the end. This 90-minute thing, I was hoping for like an hour or 45. But I want to point out something that's come from the Ombudsman, concerns about clients being treated badly in long-term care facilities, that they've been discharged, they've been isolated, they've been prevented from going back home after they've been in the hospital. They've have been isolated and restricted far beyond that and not allowed to see their families. And I'm very concerned about staffing issues there. But some of these are wrong ways to treat these individuals. And we're going to be working on that in the meantime. And it just cannot be. And so between the challenges of all the providers here, who God bless you for trying, we're going to try to get something put together here in the Senate, but keep talking to everybody who's in charge and make them understand not just the medical needs of people, but the long-term care needs of these very special individuals we all care so much about. So I'm happy to take another comment from somebody until the screen just goes black, and maybe it won't go black. Maybe it'll keep up and talking. So any comments from any other members before we
Mr. Chair, thank you.
Yeah, Senator Ralph, go ahead.
Thank you. I just want to shout out to all of these providers that have come in and testified that we hear you. And much of the stuff that's in this bill is work that I've been doing with the stakeholders. And we've been working on the PCA rate framework for almost 2 years now. And I'd like to see something get pushed across the line. So I echo what Senator Abeler says. Write your other representatives, write the governor. Please get on board with this.
Yeah, so let's test the limit of time. Does anybody else want to say anything? I just thought it was going to like turn off in like now. My clock says 4:30. So any other members want to comment? Senator Isaacson, Senator Begum, Senator Upke, Senator Ingebrigtsen, you want to invite a muskie fishing?
I would like to do that. Yes, that'd be a great experience for you. Yeah, I appreciate the committee tackling these very important issues here, and this stuff has to get done. It seems to me.
It's just critically important. So if I can slow down now talking, it seems like it's not going black on me. But I'm just going to remind individuals that there is not a consensus in the legislature or the administration to deal with paying people to stay open. If we don't find a way to keep these places open, it will be catastrophic. And I'm very, very worried about that. Senator Jensen. You have to unmute yourself, sir.
Thank you, Mr. Chair. I appreciate your holding the meeting, and I think it is important, and I think we need to keep the discussion going and encourage Governor Walz to look at what's happening and incrementally keep moving forward. So the only way we're going to do that is to have these discussions in the Senate, and I think it's important that we continue to meet. So thank you.
Yeah.
Mr. Chair.
Senator Hayden, welcome back.
Hey, how are you? Good, thank you. So I believe it's true. I really think that our focus, especially on these agencies and those that take care of our most vulnerable folks, I think that's where our focus should be. I think sometimes we get a little far afoot, and I know that there are a lot of other businesses that need to open and are trying to figure out how to make it. But I do want to thank you, Mr. Chair, and the committee for really being hyper-focused on this particular group of folks that we know if they lose their personal care, or if they get isolated, or things happen to them, then it's going to be catastrophic. So thank you so much for being hyper-focused with this particular set of providers and patients and clients.
Yeah, thank you. And I want to point out there's a number of letters in the documents that are there. And to the people I rushed through, I really didn't like to do that to you all. But if there's a niche that we didn't pay attention to, that we need to call attention about, like what to do to keep us open in this day after time, we need to know that as well. But my goal is to put together a bill that's thoughtful and it covers at least the major bases of the arena of the long-term care side in particular, and then try to get that some attention with the people that are sitting at all those meetings that most of us don't get invited to. So anybody else want to offer any thoughts?
Mr. Chair.
Ralph, yeah.
Is one thing that I did get a couple of emails that I thought I'd raise at this point. It's not included in the bill right now, but there have been several of the providers and the PCAs that have asked to raise that hourly limit because they can't get people, and the people that are there are willing to do the work. And so that was something that was brought up. I don't know how that works or what we can look at, but if we can take a look at that, maybe it can be done by an executive order. I don't know, but I would like council or someone to weigh in on that at some point to find out if that's something we can do, because I'm told that would provide significant relief to the providers.
And I think that Commissioner Harpstead can adjust the hours already if she would choose to take care of the cap. But if you want to work the PCA rate increase and the providers, group home providers, is the project you're working on. And so if you want to incorporate that, I think we should ask for everything that's reasonable.
All right, I will continue to work on that then.
Yeah, and so I just whistled through an ombudsman thing at the end there. This seems very serious to me, and maybe next meeting the department can comment about what they know about that. And I'm not here to embarrass anybody, but I know they're aware of the ombudsman report, and I think it's intolerable what's going on. And I would like to, and it's their department to look into the well-being of these folks. So by then they will have had a chance to consider it and ask us, tell me what their plan is. And who's ever watching this anyplace, if it stops streaming at 4:30, I'd like to know what the reason was we were told we had to quit. Maybe something stopped somewhere that I'm not watching. So we're going to wrap it up here pretty quick anyway.
Thank you.
Brittany, anything? Oh, Senator Benson, yeah.
No.
Oh, you're just making noise. Okay. When you make a noise, then it makes your box green. So
Mr. Chair, I do
you're
have
in the green box, Senator Benson.
Yeah, I have a 4:30 meeting, so I'm going to sign off. Thank you, Mr.
Well,
Chair.
so are we. So you get to be the first person off. So well, thank you for being a part of this first hearing we've had online. Somebody figure out why they told us we had to quit at 4:30. We could have had a little more relaxed time with the individuals testifying. But thank you for being here. And
yeah, Mr. Chair, it's just the subscription kind of dictates that, but often they just don't cut you off. So it's just I'm sure the committee administrators will tell you that that's just the way the subscription works, but often you can go on longer.
So we're in the grace period here. So hey, this is free. We're in the free time now. No. Anyway, so with that, this bill is laid over. We'll take it up. Any comments anybody wants to have, call me on my cell, send me an email, get a hold of the members of the committee. Each committee really is relevant in my mind in this committee. I don't care at all, you know, what they we're all important here. We got to get this figured out. Times are critical. People have to be served well at the end. So with that, we're adjourned, and God bless you all. Thank you.
Thank you, Mr.